In one sense, Twitter versus Elon Musk is really a pretty simple case. There's only one cause of action. Twitter is suing Elon Musk for breach of contract, specific performance, and injunction. That's it. In other words, Twitter is saying, Elon Musk promised to buy our company, and Judge, you ought to make him go through with the deal. But on the other hand, there is nothing simple about this case. It's a war of the titans, one of the world's largest social media platforms, trying to force the world's richest man to buy them and to pay what now looks like a very hefty premium for the privilege. Even before the lawsuit, the battle was raging for months. Elon Musk had stated publicly that he wanted to buy Twitter, and Twitter adamantly opposed it. The two sides finally struck a deal on April 25th, and it was supposed to be consummated in October. But just a little over 2 months later, on July 8th, Elon Musk announced Twitter had breached the deal and he was going to pull back. Now Twitter has sued Musk, saying he has to go through with the deal. And behind the scenes, there's another battle raging, one you can't even see, as the world's richest and most influential law firms pit battalions of legal soldiers against each other. Right now, I can assure you that there are dozens of lawyers on Musk's team all saying to themselves, please let those escape clauses we put in work so Elon Musk can get out of the deal. And equally, on the other side, Twitter has dozens of lawyers all saying, please let us have closed all the loopholes so Elon Musk can't get out. People are going to be talking about this case for years. So whether you're a Twitter fan or an Elon Musk fan or just neutral about it, you want to understand the case that everyone is talking about. Hi, I'm Harvard Lawyer Lee, and on this channel, I take complex legal lawsuits and I break them down into easy to follow pieces so you can understand what today's biggest cases are all about. When life meets law, let's talk. And be sure to follow me on Twitter at LawyerLeeW. Let's start with a little background on the Elon Musk Twitter deal. Elon Musk and Twitter have had a love-hate relationship for many years. Elon Musk is one of the most prolific tweeters in the world. He has 100 million followers and has tweeted 18,000 times. But Elon has also been a major Twitter critic. He has complained about Twitter censorship. He's complained about bots on Twitter, which means fake accounts that post things on Twitter. He was particularly concerned about crypto bots, which have been used to scam people and to steal personal information. Musk thought he could make it better, and in January of 2022, he secretly began buying Twitter stock. When he hit 5%, he had 10 days to inform the SEC that he owned 5% of the company. Twitter says he hit that number somewhere in March, probably about the 14th, and should have disclosed to the SEC by roughly March 24th. But instead, they say he kept going until he owned 9.1% of Twitter stock. Now, in the middle of this acquisition spree, on March 26th, Elon told Twitter's chairman and CEO that he wanted to do one of three things. He wanted to join Twitter's board, he wanted to take Twitter private, or he wanted to start a competitor. Now, no doubt Twitter was less than happy with any of those three choices, but it offered him a board of directors position, probably thinking that was the least of the three evils. The offer was made on April 3rd, and on April 4th, Elon Musk disclosed his holdings, which now made him Twitter's largest shareholder. And then on April 5th, the parties signed an agreement that would put Elon Musk on the board of Twitter. Musk accepted, but then changed his mind. On April 13th, Elon Musk told Twitter's CEO that he planned to acquire Twitter. Musk made his offer public on April 14th, and at that point, it was conditioned on customary business due diligence and financing. And what is that? What is customary business due diligence and financing? What does that even mean? You might think, well, that's a set term with a clear legal meaning, probably defined by statute, because what self-respecting lawyers would use a term like that if it didn't have a clear meaning? Well, believe it or not, it's something used all the time in contracts, and it's not exactly a clear meaning. It's one of these things where everybody thinks they know what it means, but everyone has a slightly different idea, so it engenders a whole lot of litigation. Lawyers tend to stick to terms like that because they need to account for circumstances that haven't happened yet and that could possibly go wrong in the future. And the financing contingency just means, and I want to make sure I can get a loan from the bank so I can go through with the purchase. Or I need to come up with enough cash. So we'll have to make sure I can do that. So the parties don't really truly have a final deal yet. The best way I can describe it is they have a kind of deal, but they want to do a little more work before they finalize it. They want to maybe send in accountants or lawyers to kind of look over things and make sure both sides have been honest and they know what they're getting into. It's a pretty close analogy to when you buy a house. If you've ever bought a house, you probably had a couple of contingencies. The first might have been that you wanted an inspection. You said, okay, we've agreed on a price, but I want somebody who knows about houses to look around and make sure I didn't miss something big like termites or wood rot that's making the house fall down. But before you hang on to the customary due diligence idea, hold on a minute because things are about to change. Now, Elon Musk had offered that deal, but Twitter adamantly opposed it. On April 15th, Twitter's board even passed a provision called a poison pill. A poison pill is a tactic that companies use to prevent a hostile takeover. In Twitter's case, what it did was make a provision that said if one person bought 15% of the company's stock, then other shareholders could buy additional shares at a discount. The general effect would be that it would dilute the shares that were owned by Elon Musk, so they would be worth less. Now, Musk fought back in a way that had to have given his lawyers heartburn. On April 21st, he announced his offer was no longer conditional on financing or subject to due diligence, and he was ready to begin negotiations immediately. And what does that mean? Well, it's sort of like buying your house without any contingency. You'll need to show up with cash, and you're going to need to just take the house as it is without an inspection. On April 24th, Elon Musk delivered a letter to the Twitter board saying his offer was his best and final, and he sent a draft agreement, again, giving all of his lawyers a heart attack and saying the offer was not contingent on due diligence. The mega law firms worked through the night, and by morning, Twitter and Musk had hammered out a deal. The only thing that could get Musk off the hook was a company material adverse effect, which was defined by the parties to be something that happened that resulted in a material adverse effect on the business, financial condition, or results of operations of the company and its subsidiaries taken as a whole. But general conditions affecting the market did not count, nor did anything Twitter had disclosed to the SEC in the past other than disclosures under two specific headings, risk factors and forward-looking statement. But if you think that means there's no argument here, that company material adverse effect was something really clear that everybody agrees on, well, you just haven't met a room full of lawyers yet. And that's where Twitter's lawyers are hoping that they are going to have made the agreement tight enough that Elon Musk cannot back out. And Elon Musk's attorneys are hoping that they made enough wiggle room that Elon Musk can get out. Elon Musk agreed to pay $54.20 a share for Twitter stock. That was 38% more than Twitter's current stock price would have warranted. The party set a drop-dead date of October 24th, 2022 this year. Twitter says the deal also allowed it to hire and fire employees without getting consent from Elon Musk. That'll matter in just a minute when I tell you what their arguments are today. It was such a good deal that Twitter relented, and its board approved the deal that same day on April 25th. But the deal that started out with so much promise fell into disarray. By July 8th, Elon Musk's attorneys sent Twitter a letter saying Elon was pulling out of the deal. So what happened? In the July 8th letter from Elon Musk's attorney, Elon Musk said three things got in the way of the deal. Number one, Elon Musk said that Twitter agreed to share information and cooperate, and it wasn't doing that. It breached the agreement by not doing that. Specifically, he wanted information to verify the bot situation. How many of the accounts on Twitter are really just fake accounts known as bots? He said Twitter was dragging its feet about giving him the information he needed to answer that question. He specifically wanted access to what's called the firehose data, which Twitter says is essentially a live feed of data about public accounts. Twitter finally gave Elon Musk 30 days worth of firehose data, but Elon Musk says that Twitter limited his searches in it, so it wasn't very useful to him. Elon Musk's second reason for believing that Twitter had breached its agreement was he said that the bot situation was much worse than he had expected. He said that it amounted to a company material adverse effect. Remember that phrase, the one that all the lawyers are hoping falls their way? Here it is. In its public filings with the SEC, for years, Twitter has been saying that 5% of its accounts are fake or bots. Elon says the number is way higher than that. In public interviews, he's said numbers ranging from 20% to 90%. The third way that Elon Musk says that Twitter has breached the agreement is he says that Twitter terminated certain employees, slowed down on hiring, and failed to retain key employees. The result, he says, is he would be left with no way to really run the company if he took over. Twitter was incensed, and it filed suit to force Elon to do what he had promised. That's called specific performance. Not just pay damages because he breached the contract, but specifically perform it. Actually go through with buying the company. Generally, lawyers are taught that specific performance is very rare and hard to get, and that's generally true. Obviously, Twitter's lawyers are thinking that this is an unusual case because Elon Musk gave himself so few outs in the contract. In its complaint in the lawsuit, Twitter gives its theory for why it thinks Elon Musk pulled out, and it can be summed up in 2 words: the market. Twitter says that the market fell, and Elon Musk had committed to paying most of the money himself. His plan had been to sell his Tesla stock and then to take that money and invest it in Twitter. But when the Tesla stock fell along with the rest of the market, it was going to make Elon Musk sell a lot more of his Tesla stock than he had thought he was going to have to do, and so he wanted out of the deal. Now that's Twitter's theory about why Elon Musk pulled out. Now, here in a nutshell is Twitter's legal argument. They say, first of all, Elon, we gave you all the information you wanted. Yeah, sure, maybe we dragged our feet a little, but in the end, we gave you 30 days worth of firehose data and a great deal of financial data. Now, the second thing they say is, even if we didn't give you what we said we would give you, you didn't need all that data anyway. And remember, under the contract, you were only entitled to information you needed in order to close. Here's the phrase: Musk was entitled to reasonable access to information about our business, properties, and personnel, but only if it related to the consummation of the transactions contemplated by this agreement. And how many bots, they said, is not related to consummating the agreement. I mean, you already knew we had lots of bots. In fact, that's one of the reasons you wanted to buy us. So there was no reason you had to have more information about the bots in order to close the deal. You could close the deal without knowing that. And as for the financial information, they said, you haven't shown us any bank that was asking you for this financial data, so you couldn't get a loan absent having it. So we don't really think that was something you had to have either. That wasn't necessary to consummate the deal. The third thing they argue is, okay, look, even if we didn't give you the data, and even if you did actually need it, you agreed to a sale with no due diligence. So we didn't have to give you anything, even if you did need it. And the fourth thing they argue is, besides, why would we want to share anything with you, a potential competitor? Because numerous times you've said you might start a competitor. We were allowed to turn down any requests that would cause significant competitive harm. And anything we show you, we think might cause significant competitive harm. The fifth thing they suggested is, well, maybe this whole thing was really just a plot to get information about our bots, which you have been talking about for forever. And on the losing key employees issue, Twitter said, look, We presented you with an employee retention program and you refused to approve it. So if people are leaving, it's your fault for not approving the program. Twitter also suggested Elon was breaching the agreement by tweeting out negative things about the company, which had been part of the deal, that he would not do that, and by refusing to let them terminate their revolving credit line. Now, we know Twitter has filed suit against Elon Musk to force him to go through with the deal. Elon has already promised he's going to file a countersuit, and he will soon be suing Twitter in the same court in a counterclaim. Now, the contract between Twitter and Elon Musk had something called a reverse breakup fee. That means if Musk pulls out, he pays Twitter $1 billion. But it's not at all clear that Musk can walk away for a mere $1 billion. A drop in the bucket, given his estimated net worth is $230 billion. A reverse breakup fee only applies under certain conditions. Things like concerns that an agency might oppose the deal. So the parties are going to argue over whether or not the reverse breakup fee applies. Twitter asked for an expedited trial in just 2 months' time. Absolutely unprecedented, unheard of, 2 months' time. Elon Musk said he was in no hurry. He could wait, maybe February. Even that would be very fast for most cases. But today, a court set the case for a blazing fast 3 months from now in October. The trial supposedly will last just 5 days, which is extraordinarily short for a deal of this magnitude. So hang on to your hat. Be sure to subscribe so you can learn more about what is going to be one of the biggest cases of this century.